Good.
Good evening to all of you. Yesterday I was not feeling well. Even today I'm not in good state of health. But still we didn't want to lose the continuity. Whatever it is, we'll proceed. Here, section 13 says how consent is defined. Consent means the question is how you express your willingness to do or not to do, or abstain from doing or forbear from doing. That is what is called consent. మీ అనుమతి ఇస్తారు చూడండి అది కన్సెంట్ అంటారు. The question is, as far as consent is concerned, the next section says it should be free and fair and it should be transparent. It should not be under any of the elements where you are put on threat of fear, coercion, undue influence, misrepresentation, fraud, or mistake, unilateral and bilateral. So the question is, consent when it is given to enter into a contract, it must be free and fair. It should not be tainted with any illegality. That's what free consent means. Then with your mind and body, you must consent or you must agree to that particular contract. That is called free consent. The next one is we go to the chapter called Vitiating Elements of Contract. That is what is called, first one is section 15, speaks about coercion. Coercion is when there is a threat to commit an offense punishable under the Indian Penal Code, or trying to put a person under fear of threat and to bodily harm and injury, not only to his person but also to his property, and wrongfully restrain him and confine him in order to obtain his assent. It is said it is vitiated by coercion. Coercion is jabardasti or balavantam toti. That's what in Telugu it is called. When it is obtained, it is no consent at all. The contract is voidable at the option of the party whose consent is so given under the influence of coercion. Mostly the commonest example of coercion can be when in labor law you have got one instrument called Gerau, where the manager is Gerau and is compelled to comply with your demands, and he is put under wrongful restraint, he is put under wrongful confinement, and is not even allowed to answer his calls of nature, and under those circumstances his consent is obtained or his signature also is obtained. Then in that case it is said the contract is vitiated by coercion. That is committing any offense that is punishable under the Indian Penal Code where such a threat to body or threat to the property or threat to the family members, not only to the person but also to the property, they are placed under wrongful restraint and wrongful confinement. At that particular stage, please remember, you may be the boldest person on earth, but at that stage, your brain becomes inert. Your brain refuses to work. And please remember, under those circumstances, you execute a document or agree to give your consent. Then it is said the contract is voidable at the option of the party whose consent is so obtained. Then we go to what is called undue influence. What do you mean by undue influence? Undue influence means where one person is in a dominating position compared to the other and uses that position to his advantage and to the detriment of the other, or he is in a fiduciary capacity. That means when he is in a dominating capacity compared to the other, and the other side has no other option than to succumb to your pressures and then give his consent. Then we say it is vitiated by undue influence. The commonest example of undue influence can be a guardian and what, minor and his guardian, then husband and wife, then it can be a mother superior and the disciple, or it can be any other thing. Yeah, but it can be the shareholder or the director and the company. So in all these cases, it is said undue influence is present. That is, the cardinal principle is once a person is in a fiduciary capacity, means fiduciary means once he is in a dominating capacity compared to the other, uses that position to his advantage, and the other side has no other option than to succumb to your overtures and then consents to it, then we say the contract is vitiated by undue influence. The leading case on that aspect is the case of Alcard, ALLCARD, Alcard, ALLCARD versus Skinner, SKINNER, Alcard, ALLCARD versus Skinner, SKINNER. This was also called the sisterhood case. In this case, what happened was, even now that custom is prevalent in Christians, where this Alkar, who wanted to join the church. That is in Telugu, they say Jagame Maya and all these things. She was singing that song and said he wanted to renounce the world and join the sisterhood. Then she wanted to join the sisterhood and approach the mother superior, that is Skinner, who was in charge of the church. She said, if you are going to join the sisterhood, you have to renounce all your properties, give up all your properties, and dedicate those properties in favor of the church. Here, one basic thing you must remember is the mother superior was in a position to dominate the will of her disciple, because the question is, she was in a fiduciary capacity, and this Alcad had no brain of her own. She succumbed to that pressure and dedicated all her properties to the sisterhood. Please remember, after some time, she developed a hatred for the church and wanted to go outside and live happily and lead a married life. Then, after that, 3 years after she came out of the sisterhood, she brought an action against the mother superior, claiming that her consent was not free and she was completely under the dominance of the fiduciary capacity of the mother superior. She dedicated all her properties in favor of the mother superior, and so she should be out. She should be allowed to take back all her properties, as it is influenced by undue influence, and that her consent was not free. In this case, the court negated the version put forth by the Alcad by saying that she came out 3 years after that and brought an action against the mother superior, and she had independent legal advice outside, and she brought an action, and she has come at a late stage, and since she has come at a late stage, she is not entitled to revoke this dedication which is made in favor of the sisterhood. That is a leading case on that particular aspect. Am I making myself clear to you, please? Then again, in this aspect, I will also lead. I'll also take you to the corporate law. There is more particularly the company law, where they say company has no brain, company has no conscience, company has no mind. It requires a human agency to run its day-to-day affairs, and the human agency is in the form of board of directors headed by the managing director. And the board of directors, headed by the managing director, guide the destiny of the company in its day to day functioning. So the question is, these board of directors are in a fiduciary capacity compared to the company. All their actions should be above board, and they shall not act to the detriment of the company, and they shall always act to the benefit of the company. And if anything is done, it is open to the company to bring an action to set aside that transaction. Please remember, because the company has no brain and conscience, it cannot act on its own. It requires the board of directors, headed by the managing director, to conduct its day to day affairs. The question is, the managing director or the directors are responsible not only to the shareholders, to the third parties, also to the creditors in general. The people look at the directors of the company to enter into a contract with the company, and the company should not suffer because the acts of misfeasance on behalf of the directors. So that is one of the cases where the directors are in a dominating position compared to the company, and they are answerable to the company in case they act to the detriment, and the transactions entered into by them beyond their powers can be set aside by an action brought by the company against the erring directors. So next one is what is called fraud. Please remember, most of our advocates, we commit a mistake. As far as every action is concerned, under the Limitation Act, there is a limitation period prescribed for every action that has to be brought in a court of law. That is why it is said, UB jus, EB remedium. Wherever there is a right, there is a remedy. But law of limitation, or what is called in Hindi as the Muddat ki Kanun, or కాల పరిమితిలో ఒక వ్యాజ్యం చేయాల్సి వస్తుంది. చేయకపోతే మీ రెమెడీ వాట్ ఎవర్ remedy you have to get is barred, but the right remains. What is the use of having that right when you don't have the remedy? So the law of limitation operates as a bar to the actions being brought beyond the period of limitation. So that is the reason, sir, fraud. Most of our advocates, what to do, as far as if you see the Limitation Act, fraud, there is no limitation at all. Fraud is not on the day when the fraud is committed, but on the day when the fraud is discovered. The day of discovery of the fraud day when the wrongful act has been done, from that period, the limitation starts running. So when you allege setting aside an instrument on the ground of fraud, all the valid ingredients of fraud has to be pleaded. You will also have to state clearly in vivid terms as to when you discovered the fraud, when the fraud was committed, when it came to your knowledge, and what action you have taken after it has come to your knowledge. Then you approach the court. Then in that case, fraud is proved and established. So it's easier to plead fraud than proving fraud. Fraud, what is exact definition of the word fraud is where there is an intentional representation made by a person without caring for its truth or otherwise. Number one, where an intentional misrepresentation is made by a party without ascertaining the truth or otherwise. Or second one is where the person making the representation knows that it is false, but still he wants to induce the other side to enter into a contract with you, then it is said it is vitiated by fraud. Well, as far as fraud is concerned, there is no limitation period. But when you write the plaint, in the plaint you have to clearly say when the fraud was committed, when it has come to your knowledge, how it has come to your knowledge, what was the basis on which it has come to your knowledge, what are the documents you have taken in order to discover the fraud. Then in that particular case, 3 years period is given from the date of discovery of fraud. So fraud means and defines as where an intentional misstatement is made by a party without verifying its truth or otherwise, or when a statement has been made by a person and the person to whom it has been made acts on that representation, changes his position, which he would not have done but for the representation, then we say that it is vitiated by fraud. First one is where you make it recklessly without knowing its truth or otherwise. Second thing is you know that it is false, but still you make that statement. Then in that case, it is said it amounts to fraud. But please remember, easier said than done. When you write the plaint, you will have to plead the instances of fraud, how you have discovered it, when it has been discovered, and what was the means through which you have discovered it, and how you have discovered it. And you will also have to say on that particular day you have discovered it, and from that day the period of 3 years starts running. So this is how fraud is. Intentional misstatement made with an intention to compel the other side to enter into a contract. Second one is intentional misstatement made though you know the truth or otherwise of the misstatement, and in order to induce the opposite side to enter into a contract with you, which you would not have done but for that misrepresentation or but for that misstatement, then it is called a fraud. Or I can define it shortly by saying a representation made with deceitful means in order to induce the opposite side to enter into a contract with you and to deceive the other person or commit an act of deceit whereby you defraud the other person. All these allegations will have to be clearly stated and established also. And you'll also have to state what was the means through which you have discovered the fraud, how you have come to know of the fraud, what was the date on which the fraud was committed, what was the date on which you have come to know about it, what was the date from which the period of limitation starts running. All these things will have to be clearly pleaded and established in a plate which you file into the court. Please remember, as far as fraud is concerned, there is no limitation, but still you have to satisfy the ingredients of section 17. Is it clear to you, please? Then we go to section 18. Section 18 deals with what is called misrepresentation. Misrepresentation, where a person makes a misstatement without verifying its truth or otherwise in order to induce another side to enter into a contract with you and to give his consent. That is the first one. Second one is when you make it innocently without proper verification, however innocent or modified it may be, it amounts to a misrepresentation. Misrepresentation is a lesser degree than fraud. In fraud, the element of deceit is present. But as far as misrepresentation is concerned, you make a misstatement without verifying its truth or otherwise, without verifying whether it is true or correct, or in order to induce the opposite side to enter into a contract with you, it is called misrepresentation. Then we go to what is called uh, voidability of agreements. All the above mentioned elements are called vitiating elements of contract. The consent is not free. There is no free consent. And then, when the free consent is not there, it gives an option to the party who is taken for a right to avoid the contract and to resign from the contract. But one condition is whatever benefits you have had and received under voidable contract, you have to restore it back to the other side because you cannot enrich yourself at the expense of the other when you want to resign from it, when you want to avoid from it, when you want to resign from it, or when you want to take back your consent or so, you will have to restore the benefits because under the principle of unjust enrichment, you cannot enrich yourself. At one stage, you resign the contract. At another stage, you don't want to return the money. That is not possible. Then we go to mistake. Mistake is of two types. One is called unilateral and another is called bilateral. What do you mean by unilateral mistake? That is, it is said that procedure for setting aside by undue influence. Section 20, I said, Section 20 deals with what is the procedure that is followed. That is, once the undue influence is paid on you, it is said undue influence means when a person is in a fiduciary capacity or a dominating capacity compared to you and takes your consent, which you would not have done under normal circumstances, immediately when you come to know about it, you must bring an action within the time frame that is granted to you. You cannot wait and see for a long time and then bring an action. Even if I discuss the case of Alcar versus Skinner, it operates as an exception. If you wait for 5 years when you have independent legal advice outside, your remedy is barred. Then we go to section 21, bilateral mistake. What do you mean by bilateral mistake? Bilateral mistake means where there is no consensus ad idem. Consensus, CONSENSUS. CONSENSES. That means there where there is no meeting of minds and body in order to enter into a contract. Both the parties are laboring under a mistake. I think in a one way and you think in another way. And let us say survey number 90. I think I in my mind as an acceptor think that is survey number 90 by A. Both of us do not agree as to the survey number. There is no meeting of minds. There is no meeting of minds as to the subject matter. When there is no meeting of minds as far as subject matter is concerned, there is no consensus ad idem. And the other person thinks that it is not 90 by A, but survey number 90. Then, in that case, when both the persons are laboring under a mistake, the contract is supposed to be that is supposed to be void. Then unilateral mistake. Unilateral mistake means where the mistake has been committed by one party and not by the other party, the contract is void. Then, sir, we go to effect of mistake of law. Please remember the basic principle of law is ignorantia factus excusat and ignorantia legum, not a non-excusat. What do you mean by ignorance of fact is an excuse in law, but as far as ignorance of law is no excuse at all. But suppose let us say there is ignorance as far as the fact is concerned, they can be corrected and the contract can be treated as voidable and decide at the option of the party whose mistake has been committed. But as far as ignorance of law is concerned, ignorance of law is no excuse. Every citizen of this country is supposed to know the law of the country. And suppose you say, I do not know the law, I do not know the procedure, please remember that is not an excuse in a court of law. Then, sir, we have what is called Section 23. Section 23 is, it says that what consideration and objects lawful. What consideration and objects lawful. Here, suppose let us say objects. For example, suppose I enter into a contract with you and I try to say that my house which I've leased out to you, you must use it as a brothel, or you must use it as a prostitute den, or you must use it for a purpose to overthrow the established government of the state, or you must use it for unlawful purposes, or you must use it for matka, or you must use it for what is called casino, or you must use it for betting, or you must use it for some other purpose which has been declared as unlawful by the government, then in that case, the objects for which it has been let out is illegal or unlawful. But the consideration which passes, the money that has been paid, the money which has been agreed to be paid is also unlawful. Why? Because it has been paid for an unlawful object which is not enforceable as far as Section 23 is concerned. Then we go to void agreements. 24 is agreement void if consideration and objects unlawful in part. Here, here, agreement void if consideration and objects unlawful in part. Here, no doubt everyone is free to lease out his property. Everyone is free to let out his property. Everyone is entitled to give his property on rent. But the objects for which it is given, partly it is unlawful, partly it is illegal because you give it for a purpose which has been declared by the government as illegal. Then in that case, the agreement itself fails. It is called a void agreement. Even though it may be void in part, still the entire agreement goes. That is what Section 24 deals with. Then 25 is the most important section, sir. It says agreement without consideration void unless it is in writing and registered or a promise to compensate for something and register something that is something done or is a promise to pay a debt barred by limitation. Most of you know that we are dealing with the financial institutions every day in and day out. As far as the financial institution is concerned, it is run with public money. If every person takes a plea of litigation, what would happen is the bank will go bankrupt. You will have a lot of NPAs, then performing assets. So in that particular case, they say, suppose within 3 years period, which is the period for litigation, the banker takes three documents called COB, that is confirmation of balances, AOD, that is acknowledgement of debt, and third one is revival letter. Then in that case, or he pays some money towards the account in part payment of the debt, then in that case it extends the period of limitation and a further period of 3 years is given. But here the question is, even if a time bar debt is there, suppose there is an agreement to pay and it is made within a period of 3 years, it extends the period of limitation. So it is said agreement without consideration is void, but in a promise to pay and a time bar debt within that period of 3 years extends the period of limitation for a further period of 3 years. That is what Section 25 deals with. Then Section 26 is restraint of marriage void. Please remember, unfortunately, in most of our families, we expect that the property should remain within one's own family. There's nothing wrong about it. Suppose the old man is there, he wants the sister's daughter to be married to the brother, to the son, to the and that is the daughter's daughter to be married to his son's son. Why? Because the question is dowry is not paid. Even if dowry is paid, it comes back to the same family. And then once you get a child, the child is again married in the same way, and that property comes back to you. That's how the property is rotated or perpetuated within one's own family. Then the question is, in Andhra especially, there is a custom that usually the Manamama, that is a maternal uncle, marries a sister's daughter. And in some most of the movies and TVs, you see that the Manamama has got the first right, or he's got the preemptive right to marry his sister's daughter. You cannot offer your sister cannot offer a daughter to an outsider without giving the choice to her brother. And the sister occupies dual positions here. She not only becomes the mother in law, but also becomes the sister in law of the daughter. But these things are very, very prevalent. And normally it is said one of the ways of perpetuating a property within one's own family is get your son married to your sister's daughter, or your sister's son married to your daughter. ఇచ్చి పుచ్చుకోవడం అంటారు చూడండి అది. The question is the property does not go outside. That's how you remember. And this is very, very prevalent or common in Kammas especially. They don't want the properties to go outside. That is the reason we have unfortunate crimes today. Honor killing. Honor killing is, of course, I don't want any person here from the Kamma committee, I don't want to wound their sentiment. It is said, suppose a girl marries outside the community, the husband is finished. Why? Because they don't want the property to go outside. There are various means of keeping the property within one's own family. So here it is said that agreement of restraint of marriage is what you cannot say you marry my daughter's daughter or you marry my son's daughter. Such a type of restraint cannot be imposed. Please remember, nowadays those restraints are all gone. Now your son or daughter marries outside the caste, you have to reconcile. పెళ్లి చేస్తావా సస్తావా sometimes what happens is your wife will try to impose restrictions on you and say చేస్తే చేసుకుని వాళ్ళు సుఖంగా ఉంటారు కదా. The question is, nowadays you cannot exercise control over your children, be it a son or be it your daughter. When they come of age, they marry of their own choice, and that's the reason why we are having mixed marriages in most of the communities today. A Hindu marries a Christian, a Hindu marries a Muslim marries a Hindu, so on and so forth. But unfortunate thing is, though we call it as national integration, but the people from other communities don't get converted into your religion. That's absolutely myth, absolutely absurd. The question is, and please remember, a classic example I can give you is the marriage of Nawab Pataudi, Mansoor Ali Khan, with Sharmila Tagore. Even today, Sharmila Tagore is called as Sharmila Tagore and not as any Muslim name. The question is, she is allowed to practice her own religion. That sort of coexistence should be there. Respect every religion, respect every caste, allow everyone to use their own religion and use these religious practices. Religious practices. Absolutely, there's no problem. That's why they said, "Miya will be raji hai to kya karega kazi." Even the parents will have no control over it. Nowadays, you will have to compromise and settle the matter at the nutshell itself. If you don't do it, you have the threat of your daughter or son running away from the house and marrying outside the community. So any restraint that is imposed, any restriction that is imposed, any you see in movies also. Suppose ఆ అమ్మాయిని నువ్వు చేసుకున్నావు అంటే నీకు ఆస్తిలో ఒక చిల్లి గవ్వ కూడా దక్కదు. I said, care your damn for your bloody money. Take care a damn for your property. I am loving that girl. I'm going to marry that girl. That's all. Please remember, children have become very, very independent now. They have got their own choice. They have got their own liking. They have got their own way of choosing their better halves, and so on and so forth. The question is, of course, we are going to the extreme ends also. Especially, I've seen people who belong to the lower communities. There they have అబ్బాయికి అక్క మామలు ఉండకూడదు, ఆడపడుచులు ఉండకూడదు, దెన్ ఎవరు ఇంటికి రాకూడదు, మీ ఇంటి వాళ్ళు ఎవరు రాకూడదు, ఎవరికి నేను ఒక పూట భోజనం కూడా పెట్టాను. Their entry into my house is barred. The question, all these silly objections should be waived. When they marry of their own choice, when they choose their own life partners, allow them to choose their own life partners. Tomorrow they are going to live together. Whether they live together or separate from each other, we do not know. But still, their choice or their liking has to be honored at all circumstances. That is the reason it is said restraint of marriage of all forms is void. Then we go to section 27, restraint of legal proceedings. Here, restraint of legal proceedings except arbitration. Yeah, especially if you have gone to the Arbitration Act. Arbitration Act, we have two acts. One was in 1897 or 1887, where in the old act, suppose you move for arbitration, mediation by a third party, and nominated by you and other side, and the award is given by the arbitrator, then the award of the arbitrator is final unless it is set aside by the court under the provisions of Section 4 of the Arbitration Act. And in case you want to recover any money that is due under the arbitration award, you will have to file the award into the court and then ask the court to make it a rule of the court. That was the old law. But in 1996, they amended the Arbitration Act and passed a new act called Arbitration and Conciliation Act of 1996, whereby they say any award passed by the arbitrator or arbitrators, as the case may be, is full and final, and they can be implemented, they can be enforced like a civil decree. And straight away you can file the award into the court, and all the remedies that are open to you under the civil procedure code can be exhausted. Either attachment of salary, attachment of movers, attachment of removal, or arrest and attention in civil prison, or appointment to receive, so on and so forth. There is a drastic amendment that has been brought about under the Arbitration Act. But here under the Arbitration Act, one thing you must remember is the procedure of making it as a rule of the court has now been removed. Under the new act, it is said straight away when an award is passed, it is something like a money decree. It can be enforced as if it is a money decree, and all the provisions that are available under the Civil Procedure Code for execution under the provisions of Order 21 applies as far as the arbitration award is concerned. Here, the question is, there is one more section two more sections important. So three sections are important in the Arbitration Act. One is Section 8. Once a suit is filed for money, let us say, there is a clause for arbitration saying that no suit can be filed in a civil court unless the parties submit themselves to arbitration. Then at the first instance, when you appear in the court, you must file a memo saying that a civil suit is not maintainable. There is a clause for arbitration. The question is the question is it should be sent to arbitration and a civil suit is not made. At the earliest time, you must raise that objection. Then there is one more provision called Section 9, which says prohibited or preventive reliefs. You can also ask for an injunction as far as the Arbitration Act is concerned, not to alienate the property, not to transfer the property, not to deal with the property in any manner. You can take an injunction. But it's only valid for 3 months. After 3 months, automatically it gets dissolved. And the question is, unless it is extended from time to time. Then we have got one more provision called in the Arbitration Act called Section 11. As far as previously it was concerned under the old Act, the lower courts, that is the district court, was empowered to appoint arbitrators. But now that power has been taken up, and now only the High Court under Section 11 has been empowered to appoint and nominate arbitrators. Then it is said that here it is said restraint of legal proceedings is barred. You cannot prevent any person from instituting a legal proceedings in a court of law. That is the corresponding provision you have in the Specific Relief Act, also called Section 41. In those cases, the restraint of legal proceedings is barred. The next one is Section 29. It deals about uncertainty. Uncertainty means uncertainty. That is, whether it may happen, it may not happen, and it is nothing certain, it is vague and ambiguous. Then, in that case, the contract is supposed to be void. Then, the next one we go to is wagering contract. That is, wagering contract means where there is a chance of one person to win and there is a chance of the other person to win. Though chance of winning is not guaranteed, chance of losing is not guaranteed. One person wins and the other person loses. Then, in that case, it is said the contract is supposed to be void. But except in the case of horse racing, jackpot, etc., where the government also has encouraged these sports by saying horse racing because it gets revenue to the government, especially when you win a jackpot, you have to surrender 30% of the jackpot amount to the government by way of income tax. Income tax. But as far as lottery is concerned, even in the case of lottery, if you get the prize amount, out of that 30% is deducted towards income tax, and that has to pay to the government. Or about the crossword puzzles, if you get any reward, 30% of it is deducted and it goes to the government. And all these cases, except those, the wagering contracts are supposed to be. I think I cannot go on further. Yes, I'm having a very bad cold and I'm not keeping well. Anyhow, I didn't want to lose the continuity. Please bear with me for 1 or 2 days. I'll be all right completely and we'll go at a faster pace. We have completed up to Section 30 of the Contracts Act. Any questions? Yes, any questions, please? By way of interaction. Any questions by way of interaction, please? Any questions by way of interaction?
Sir, good evening, sir.
Good evening, Mr. VRK.
Sir, good evening, sir.
Good evening, Bob. Yes. Yes,
sir, there is a doubt on pronote case, sir.
Yes.
ప్రోనోటు ఒకరి పేరు మీద రాశారు సార్.
Yes.
మదర్ పేరు మీద ప్రోనోట్ ఉంది.
Sure.
అయితే మదర్ ఒక సిగ్నేచర్ చేశారు, కింద సన్ చేత కూడా చేయించారు సార్.
దేని కింద ఇది సాక్ష్యం కిందనా లేకపోతే షూరిటీ కిందనా?
షూరిటీ కింద, దానికి మదర్ కిందనే పెట్టారు. మదర్ ఏమో 1 రూపీ మన రెవెన్యూ స్టాంప్ మీద పెట్టారు,
సార్
కిందేమో ఆమె సన్నుతో చేయించారు.
అది కాదండి.
అది ఇప్పుడు
ఆన్ డిమాండ్ అండ్ ఆర్డర్ ఐ సోల్సో డూ పే టు సోల్సో అనేది ఉండేటప్పుడు అంటే ఎవరైతే ప్రాంతంలో రాయించుకున్నారో వాడు ఒక్కటే పేరు ఉందా, 2 పేర్లు ఉందా?
ఒక్క పేరే ఉంది. సంతకాలేమో కింద 2 ఉన్నాయి. ఒకటేమో స్టాంప్ మీద, ఇంకోటేమో మామూలుగా రాశారు, మామూలుగా ఉంది. ప్రోనోట్ మీద మాత్రం ఒక పేరే ఉంది.
ఒక పేరు ఉంటే ఓన్లీ దట్ మదర్ ఇస్ ఎంటైర్డ్ టు రికవర్ దట్ డెట్ సార్, నాట్ ది సన్.
ఓకే, అయితే ఇద్దరికి నోటీసులు పంపించారు సార్.
అది
మనమేమో డిఫెండెంట్ తరఫున.
The question is you will have to take a plea, say that notice has been given on behalf of the mother perhaps.
Oh.
So notice your mother taraf ichinante. The question is, as far as the payment is concerned, it should be done to the mother or the son. The question is, since the son has signed, he is also the person entitled to the enforce the promissory.
But the notice is given responsible for both, sir.
Then the question is
మీరు కలిసి తీసుకున్నారు అని నోటీస్ ఇచ్చారు.
The question is, as far as the son is concerned, he'll escape because he is not an obligate, co-obligate. But as far as the mother is concerned, mother is an obligate, so she is liable.
Okay, she is only. Yeah. It doesn't come under joint pronote, sir.
లేదు రాదండి. క్వశ్చన్ జాయింట్ ప్రామిసరీ నోట్ అని వచ్చేటప్పుడు వాళ్ళిద్దరు కలిసి రాసి ఇచ్చినట్టు రాయాల్సి వస్తుంది. జాయింట్ ప్రామిసెస్.
Okay, thank you.
And another thing I would like to remind you, sir, always printed forms don't depend on printed forms. Printed forms కింద జామీన్ అని ఉంటుంది, షూరిటీ అని ఉంటుంది. అది మీరు ఫిల్అప్ చేశారంటే it becomes a bond. Then you will have to pay 3% from 3% of 100 rupees towards the value of the amount. It is not enforceable as a promissory note. It becomes a bond. If it becomes a bond, then the question is the duty and penalty has to be paid.
Okay, right.
As far as possible, it's better to type out a promissory note rather than depending on printed forms.
Okay, right. Okay, right.
Welcome, welcome, sir. Any more questions? Any more questions, please? Any more questions? Any more questions?
All right, sir.
We'll wind up.
All right, we'll wind up the class for today. Thank you very much. We'll see you tomorrow again.
Don't mistake that my admins are admins actually. They are all my colleagues in my same office. They are helping me out, helping an old man.
Not like that, sir.
And another thing, they are actually the people who have prompted me to take up these online lectures. At this age, I would not have done it because 28 years enough. I worked in the university. I taught about 16 subjects there. Thank you very much.
Thank you much. See you soon tomorrow.